Greetings and welcome to Understanding Evidence, Applicability. We're going to be going over the final section here on Understanding Evidence. Hello to Bill Thomas from California, and anyone else that hops in here, please hit the like to make sure that we get the word out about this information so we can all have something to learn from and feedback with each other while we're learning. With that said, let's get started. We're on to applicability. First is motion in limine. At any time prior to trial, and in some cases during trial, any party may file a motion in limine, pronounced, limine. Limine. All right, say it, my Latin's not the best, but limine. To exclude evidence the other party is trying to offer. So a motion in limine is a motion to exclude evidence the other party is trying to offer. The term means at the threshold, at the very beginning, preliminarily, and applies to the motions being brought before trial to preliminarily prevent introduction of evidence that is irrelevant or otherwise inadmissible. Before we go any further, I just want to remind everybody that this is not to be used for anything other than the informational, educational, entertainment broadcast. It's not to be used for anything legal, lawful, professional, personal, tax-wise, or financial planning. So don't do this at home. Let's proceed. Limine. Okay, so limine is how we'll say it. So motions in limine to prevent offers of adverse evidence is a very smart thing to do. For example, in an actual case we handled here in Florida, the defendant stole trade secrets from our client then. Using those trade secrets, stole our client's customer base. Jerks. In their affirmative defenses, they alleged that the customers would have left anyway. We successfully prevailed on the court to grant our motion in limine to prevent the other side from introducing certain evidence in support of their would have left anyway defense, on the basis that the offered evidence was not relevant to our cause of action for theft of trade secrets. So here we go. They're saying that stole a client's customer base using trade secrets. So this is implying they use those trade secrets to create a separate business and then stole the client's customer base or sold those trade secrets to a competitor. And when they claim they would have left anyways, that's actually irrelevant to the fact that they stole trade secrets. So, we successfully prevailed on the court to grant our motion in limine to prevent the other side from introducing certain evidence in support of their would have left anyway defense, on the basis that the offered evidence was not relevant to our cause of action for theft of trade secrets. If the defendants had not stolen our client's trade secrets, we'd have no case against them for stealing customers. They would have left anyways defense was not relevant to our action for theft of trade secrets. We're not for theft of customers, it's for theft of trade secrets. That's the case. So the evidence about client's customer base is irrelevant. So a motion in limine would prevent that evidence from being entered. In a similar matter, the defendant sought to introduce a newspaper article to prove our client had participated in some activity that, if shown to the jury, would mislead or prejudice the court. Though a newspaper itself may be self-authenticating, an example, it is what it purports to be. The content of an article in a newspaper is hearsay that does not fall under any exception to the hearsay rule. So the content is hearsay. The document itself may be thought self-authenticating, but the content is hearsay. The article was an out-of-court statement offered to prove the truth of the matter asserted in the article, so we filed a motion in limine to keep it out. Some judges don't like motions in limine. They don't want to be bothered by ruling on evidence before trial begins. Don't fall into the trap of being afraid of judges. Motions in limine are authorized by the rules of evidence and are used by winning lawyers. If you can keep evidence out before trial, do so. So, good advice here. And let's flip over to the chat. All right, I'm like Tom with Audit Them. Welcome. And Captain Jack, ahoy. So let's continue on here. We're on to testimony by attorneys. Hang on a second. Did we learn something about this before? Yes, we did. As a rule, attorneys representing their clients in court are not permitted to testify as to facts about which they have no personal first-hand knowledge. And if they do so, they should be disqualified as counsel for their client and placed under oath. So they become a witness. The only exceptions are 1, in opening statements at the beginning of trial when the lawyer may say to the jury, "Ladies and gentlemen, the evidence you are about to hear will show." Or 2, in closing statements at the end of a trial when the lawyer may say to the jury, "Ladies and gentlemen, you have heard evidence that showed." It is improper for lawyers to testify, yet it happens all the time. Wow. Just as in opening and closing arguments, a lawyer arguing a motion hearing may tell the judge, "We will present Mr. or Mrs. So-and-so who will testify that." However, the lawyer should never say, "Defendant was wearing red shoes the day of the accident," unless a lawyer was present. Yeah, the ambulance chaser, he was first on the scene. Unless a lawyer was present, has first-hand knowledge of the fact, and is testifying as a witness, in which case he is disqualified from acting as counsel to a party in the case. Don't let lawyers testify in your case. If a lawyer begins to tell the court material facts instead of saying what the evidence will show or has shown already, jump to your feet and object. Move the court to put the lawyer under oath and to disqualify the lawyer as counsel. No one is competent to testify to facts about which he has no first-hand knowledge. That includes lawyers, who all too frequently mislead judges and prejudice juries by proclaiming the truth of matters about which there has been absolutely no admissible evidence presented. Don't let it happen to you. Oh boy, now we're on to dealing with perjury. Perjury is a crime. In some states, it is still a felony punishable by imprisonment. Remarkably, however, it is commonplace practice by witnesses and even by lawyers who not only improperly testify about facts they do not know firsthand, but testify about facts that are not true. Anything to win a lawsuit and make more money in fees. The first rule is to require all testimony to be under oath and on the court record. First rule, require all testimony to be under oath and on court record. If a witness or lawyer has not been sworn, he or she can lie with impunity. It is not perjury to lie in court. It is only perjury to lie under oath. Moreover, it is only perjury if the person testifying is aware his testimony is false. Plausible deniability right there. Finally, the perjury must be relevant to some material issue of fact. The perjury must threaten some prejudice to the other side or to the administration of justice generally. If a witness or lawyer lies under oath, move the court for an order to show cause why that witness or lawyer should not be held in contempt and press for contempt. It's hard enough to win a lawsuit when everyone tells the truth. So here we go. If a witness or lawyer lies under oath, move the court for an order to show cause why that witness or lawyer should not be held in contempt. Show cause why that witness should not be held in contempt. And press for contempt. It's hard enough to win a lawsuit when everyone tells the truth, let alone when you get a bunch of lying witnesses under oath. Okay, and we're on to the good part here, direct and cross-examination. Before we get on to this, let's double check in the chat here. Yeah, we'll have music at 3 a.m. from Audit Them on the Audit Them channel. It's probably Central Standard Time or Daylight Time. All right, let's get back to the broadcast here. And direct and cross-examination. Cross-examination is an extremely powerful tool for getting at the truth. Being able to tell a witness a fact and make him admit it, as may be done during the discovery phase with requests for admissions, as explained in our other tutorials, can be devastating to a liar on the stand, or someone who wants to hedge the facts and dance around the truth with innuendo and half answers. For example, the following is a leading question permitted during cross-examination, but not during direct examination. Is it a fact that you've read part or all of the blah, 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 whatever that said there, tutorial on evidence? Yes or no? Now, what if you couldn't ask the question this way, but were required to develop your line of questioning, one element upon another, until you've created a predicate for your questions? An example, you drew the witness out until he stated an answer to a direct question. I've read part of the blank tutorial on evidence. Harder. So one is, isn't it a fact that you've read part or all of the so-and-so tutorial on evidence? Yes or no? Right? That's a leading question that's permitted during cross-examination, but not during direct. So if we're going to develop a line of questioning, right? You want him to answer to a direct question. I've read part of the so-and-so tutorial. Harder, yes. The point of this is to make certain you understand before we end this tutorial, you cannot ask leading questions except in certain situations, and you must learn how to get the testimony you want with direct questions when cross-examination is not allowed. So you see what we're getting at here to elicit the proper response when direct and when cross. In general, though there are exceptions in local rules that vary from state to state, you may not cross-examine, an example, ask leading questions of your own witnesses. An example, the witnesses you call. You may cross-examine the opposing party and witnesses he calls, but you may not cross-examine your own. When examining your own witnesses, you must use direct questioning to elicit testimony you want to hear in court. Witnesses called to the stand by the other side can be cross-examined by you once the other side contemplates his direct examination. Don't let the other side cross-examine his own witnesses. Object at once, stating that grounds for your objection. Make your record. Do not allow it. So, objection, cross-examining his own witnesses. Don't let the other side cross. Okay, here we go. One exception is where a witness you call turns hostile or begins to lie. Holy goodness. Bad choice of witnesses there. Turns hostile or begins to lie. If you can convince the judge to declare your witness hostile, he'll be treated as if called by the other side, or even as if he were an opposing party, in which case you may impeach your own witness and cross-examine him to get at the truth. You can always cross-examine opposing parties, so it looks like you have to have a hostile witness on your side before you can cross-examine them. The reason you aren't permitted to cross-examine your own witness is because the process of cross-examination gives the examiner an opportunity to state facts and ask the witness to corroborate the examiner's own testimony. What we want from witnesses on direct examination, an example, when being examined by the party who called the witness, is not a mere yes or no as the examiner tells the story he wants the court to hear, but what the witness can say from his own personal knowledge. By requiring examiners to ask direct questions instead of leading the witnesses they call, the testimony is limited to what the witnesses know firsthand, not what the examiner wants the witnesses to know and tells the witnesses to say by using leading questions. When you call your own witness, you cannot lead. You must use direct questions to get the testimony you want the court to hear. When the other side finishes direct examination of his own witness, however, you could attack the other side's testimony with cross-examination. Remember, cross-examination is to get to the truth. In general, however, cross-examination of the other side's witness is not permitted to inquire into matters not raised by the other side's direct examination. If the other side didn't ask questions about company billing procedures, for example, you cannot inquire into those procedures for the first time on cross-examination. Unless direct examination opens the door to a particular matter, you cannot inquire into that matter when it comes time for your cross. So it needs to be first brought up by direct examination before it can be brought up in cross. An obvious exception to this rule is when examining an opposing party whom you may always ask leading questions. Obvious exceptions, when examining an opposing party whom you may always ask leading questions. Another obvious exception is when impeaching a hostile witness, which may be done with leading questions. So, obvious exception, examining the opposing party and your hostile witness. So, we're on to how to examine a witness on direct examination. Let's pop over here in the chat. Often? No. I think the lawyer was called to stand for withholding exculpatory evidence in the Rust trial. Well, we'll get to that there. Seems like some tack on a what, if any, or a isn't it so to avoid some rule. Yeah, so we're going to get into some of the details here, and the best we can with this. This is just a primer here on evidence, but how to examine a witness on direct. Direct examination is probably one of the most difficult tasks of trial lawyers. I figured as much. It is beautiful to hear when properly done, a nightmare when done poorly. Keeping in mind that the examiner may not lead his witness or in any way suggest to his witness what the answer might be to the question asked. You can see how difficult it is to get a witness to say what you wish the witness to say. For example, you may wish your witness to tell the court he's known for the opposing party nearly 40 years. So he's known the opposing party for nearly 40 years. You want him to say this. Done business with the opposing party for 10 of those years, and of his own personal knowledge can testify the opposing party issued bad checks to him not fewer than 20 times during those 10 years and 5 times during the last year alone. Okay. If you begin, Mr. Witness, isn't the fact Mr. Party gave you 20 bad checks in the last 10 years and that 5 of those bad checks were in the last year alone? You won't get past the words, isn't it a fact, before being interrupted. The other side will jump up to object, leading, and the court will surely wither you with an immediate sustained. The other side won't say objection, Your Honor. That question was leading and not permitted. It won't be necessary. He will simply say leading. His objection will be sustained while you will be required to start over. Get the picture? Try getting a family member or friend to testify to some fact you know the friend or family member knows by using direct questions alone. An example, without leading. You'll find it very difficult. And the practice will serve you well when it comes time for trial. Interesting. Let's see how we do this. Have another friend or family member sit as judge and another as opposing counsel to object when you ask leading questions. Pick some event like last year's county fair or a visit to the amusement park, something your witness is sure to remember. Write it on a piece of paper the fact you want your witness to testify to, and put the paper in your pocket. Then start asking direct questions until you get the answer you want. Go ahead, give it a try. You'll find it's none too easy, yet the practice will be extremely valuable later on when you must examine your witnesses with direct questions only. An example, without leading. Now, let's complicate the process. Oh, geez. By requiring that your questioning be constrained to matters you can convince your judge are relevant to some underlying issue, such as the witness's fear of heights. Let the judge limit your questioning when the questions seem to wander from the point you're trying to prove. Remember, you alone know that your goal is to get the witness to talk about a particular experience that happened at the fair or amusement park, the facts you wrote on the paper in your pocket. Cannot tell the judge, "Your Honor, I wish my witness to tell how he refused to ride at the double Ferris wheel last year at the fair." That's you testifying instead of getting the witness to testify. You cannot lead your own witnesses. A good way to learn direct examination is to practice with friends or family, judging and objecting when you lead or wander from relevance. Then it will be easier in court during real cases involving real issues with real stakes on the line. So I guess this is what they do in law school, used to do. Yeah, right. Okay. How to examine a witness on cross. Before we get to this, let's double check into the chat. Yeah, the good use of humor of this tutorial here, and it makes it very easy to comprehend and to digest. Diesel for We the People News says not enough attorneys or people say I deny your claim, which puts the burden of proof back on them, using everybody using ejection too often, ignore, deny. All right, so now we're on to how to examine a witness on cross. This is probably the most fun a human being can have in court. Cross-examination is a delight when properly managed, focused on getting relevant evidence and directed towards a witness who's trying to evade the truth. Well done, it will get the truth every time and uncover lies with very little difficulty. Done poorly, however, it can backfire. So learn the simple principles taught here and practice them on friends and family members before you go to court. Be ready for the real thing when the time for court arrives. So I've heard it said that no lie can withstand a proper cross-examination. The most important thing when cross-examining a witness is to remain calm, cool, and collected. The goal is to get the truth, not to rattle the witnesses, and certainly not to imitate TV lawyers like Matlock or Perry Mason, although Matlock is pretty cool. Keep cool. Let the witnesses believe you're his friend, or if it serves your purpose, let the witness think you don't know what you're doing. It doesn't matter what the witness or judge and jury think about you. All that matters are the questions you ask and the answers you get on the court's written record, where postures and facial expressions will not appear. So here is one part where you're not trying to win over the jury's heart, is during cross-examination. You're out to get the truth on record. The goal is not to look like or act like anyone but yourself. Just get the truth. Successful cross-examination deals with words, not attitudes, postures, tone of voice, or other theatrical tricks to make you seem clever and competent. The goal is to make an effective, winning record of the truth. If you want to be seen as clever and competent, ask questions in an orderly manner. As taught in all something tutorials, have a plan and work your plan. Know what your witness knows. This comes from pre-trial discovery procedures taught in our other tutorials, whereby you learn through interrogatories, requests for admissions, requests for production, subpoenas, and depositions, just what your case is all about. An example: who knows what and where to find tangible evidence that supports your position in the case. The most effective cross-examiners lead witnesses subtly by not revealing the goal of their questioning until they've laid a predicate building up to the big question that will reveal the truth about some ultimate fact issue material to the outcome of their case. Take your time. Woo the witness. You'll get more flies with honey. Just remember, this is not a thespian exercise. You're not on stage. You're not seeking answers to questions that will win your case. You're seeking answers to questions that will win your case. Nothing more. Focus on this goal. Get answers you need to win. Make a winning record, then move on. And we'll move on to circumstantial evidence. And over to the chat here. Not guilty is not the same as innocence. Innocence not. You could be found not guilty. You can never be found innocent. It's true with practice. Practice with fans and family. Fans would be great to practice with, except just gotta be careful of the blades on the fan. Go watch courts and learn. Yeah, you'll probably do better just with your friends and family and fans. The courts are full of pomp and theatrics. And tell that to the attorney. Yeah, okay. Exactly. Well, again, not to, everyone's going to make a living. I'm sure attorneys got children to feed too. All right, we're on to circumstantial evidence. Circumstantial evidence is an invention. Circumstantial evidence reaches beyond the boundaries of known truth into the realm of conjecture, imagination, and hunches. To be admissible in court, circumstantial evidence must be derived from direct evidence. It must be directly derived from direct evidence. Directly from direct. It cannot be derived from other circumstantial evidence, inferences on inferences, or opinions founded on intuition. Inferences that circumstantial evidence makes must be reasonable, or the evidence is excluded for lack of credibility. Circumstantial evidence derived from inferences built on other inferences is always excluded by reasonable courts by the rule against pyramiding inferences. This is a great one here. Pyramiding inferences. Direct facts are not disputed by reasonable persons. Direct facts may be explained by saying what indirect facts are. Indirect facts are facts inferred or surmised from other facts that are inferred, but a direct fact requires no inference. A direct fact is not surmised, nor does it arise from intuition or spiritual powers. A direct fact is not a guess or a hunch. A direct fact is a fact reasonable persons would believe without relying on a hunch. Pure speculation founded solely on conjecture or inference should not be given the same weight as facts that are clearly evident. Direct facts are clearly evident. Direct facts are therefore good evidence if they are relevant to the issues in your case. Circumstantial evidence is evidence that does not in itself exist. It is only a fiction of conjecture offered to prove a disputed issue by drawing an inference from direct facts. The quality of the inference relied upon to create circumstantial evidence determines the probative value of the circumstantial evidence. For example, if a locked house is robbed without any visible signs of forced entry, a jury may be persuaded to believe the robber had a key. At the same time, one could infer the robber knew how to pick locks, or even that the house was unlocked when the robber arrived, and that he locked the door behind him. The evidence here is susceptible of 3 separate inferences at least, and is therefore not reliable as direct fact evidence. Some jurisdictions have ruled that unless an inference drawn from circumstantial evidence is incontrovertible, an example not susceptible of any contrary reasonable inference, it should not even be presented. Wow. Most jurisdictions rule that one inference cannot be piled upon another. An example given here is inferring from the preceding circumstances that the homeowner must have robbed his own house because he was the only one who had a key. In this example, direct fact evidence is absence of any sign of forced entry. The first inference is that the robber had a key. The second inference, built on the first, that the owner must be the robber because he is presumably the only one with a key. Such pyramiding of inferences is forbidden in most jurisdictions. To prevent obvious errors, such evidence should never be relied upon to reach a verdict. An example of direct evidence in the preceding example is that there were no visible signs of forced entry. That's direct evidence, no visible signs of forced entry, a matter that needs no inference, but stands on its own as evident. The inferred conclusion that the homeowner robbed his own house is unsupported. Circumstantial evidence should never outweigh contrary direct evidence. Many troubles arise today from refusal to acknowledge the difference between direct and circumstantial evidence. A judge may properly refuse to be influenced by evidence presented only as circumstances infer. It is by this fundamental principle that multitudes today enjoy freedom. It is in the lack of this knowledge that needless sufferings occur. Truth alone is true, nothing else. Be prepared to defend the difference. And that takes us to our conclusion. Before we get here, let's double check on the chat. If you win a motion to dismiss, it almost like being declared innocent. It would depend if it's dismissed with prejudice or not. Could just be round 2 coming up. All right, so we're on to conclusion. Don't rely on the judge to help you get evidence in or keep it out. You must move the court to get what you want. You must object and give grounds for your objections. It is up to you to control your case by keeping the other side from controlling it. As stated before, federal rules of evidence require just 15 pages of official rule books. State rules are not much more complex. Not a lot to study and understand. You owe it to yourself to study the official rules of evidence that control your court, with the help of this tutorial to understand the general principles of evidence law. And with that, it takes us to the end. So I would thank you all for coming here, for understanding evidence as we went through applicability and the final conclusion of this tutorial. And I bounce back over to the chat here. And I hope everybody found it informative and educational and found something new here they perhaps didn't know or can now apply. All right, Captain Jack, ahoy to you. And yeah, appreciate all the feedback. Captain Jack brought up a great one on deep dive into a particular word of reasonableness, which has really come up time and time again. So that has paid dividends in that little digression we did do. So again, my appreciation to all of you for coming out. Let me double check on the chat here. Sometimes it doesn't refresh. Double refresh it here. There we go. Oh wow, yeah, okay. Another good survey of knowledge for everyone and get the people. Yeah, here we go. Yeah, motion to dismiss. They can come back at you even years later. Motion to dismiss with prejudice. Can't motion to dismiss without prejudice to go to prosecutor. Yeah. And Original Gangsta, thank you for coming out. Appreciate you all. And we're going to keep this going. We're going to keep the education going. I got some other great stuff on point here. We're going to have some good stuff here coming up and more ways that we can keep moving ahead with this. I think there's a lot of actionable information that we could take away from this whole series of tutorials we've gone through in understanding evidence, and by that empowering us to use some of the great tools we have to keep justice for us and posterity. So salute to you all for being here and coming on the journey with me, and I hope to see you all on the next one. Peace out.